Do you create intellectual property as part of your job or as part of your business? Do you work or run a business in New York? I'm Mike Steger. I'm a trademark and copyright attorney, and I've got some news for you about a new law in New York. Typically, you have a confidentiality agreement in your employment agreement, or there's what's called an invention assignment agreement. These are provisions in many employment agreements that say that any work that you do for the company will own. Sometimes these agreements are written very broadly, and they could be interpreted that as long as you're an employee of XYZ company, anything you create anywhere during the time that you're employed is going to be owned by the company. And it may go back and even try to bring in intellectual property or other works you created before you became an employee of the company. Well, there's a new law that went into effect in New York in September that says that for New York employees working for New York employers, those provisions are void. So that if you create something outside the scope of your employment and you don't use any of the employer's equipment, the employer is not going to own that. At the same point, if you are an employee and you create something within the scope of your employment, so something that you're being paid to do, the employer is still going to own that. Or also, if you create something outside the scope of your employment, but you use the employer's equipment or resources, the employer will probably own that as well. It's unclear for overbroad assignment provisions whether those will be struck down completely or whether they will just be what's called blue pencil refined so that they would only apply to permitted assignments. I'm Mike Steger. I'm a trademark and copyright attorney. If you have any questions, whether you're an employee or an employer, about the scope of confidentiality or assignment agreements relating to intellectual property, please give me a call.